Welcome back, guys. Let's talk about the happenings going on with XRP. So many stories coming up, and XRP lawyers led by John Dion have expressed their disapproval of the leadership of SEC Chairman Gary Gensler. I've never seen an organization that is more in need of genuine leadership than this one. Don said, modification of the $50 million SEC retreats from $50 million debt box lawsuit as community cries foul play. In light of the recent decision by the Securities and Exchange Commission to drop a $50 million fraud action against Debtbox, as well as the company's confessions of making misleading statements, the recent motion to dismiss charges against Debtbox that was filed by the SEC, Securities and Exchange Commission, has caused a stir in the community. Federal judges, including Judge Torres, have referred to CC attorneys as hypocrites in the Ripple litigation. The legal community has become more suspicious as a result of this move, which has cast a shadow over the legal arguments that the SEC has presented in other cases. Ripple's chief technology officer and a notable cryptocurrency attorney have both voiced their displeasure with the SEC's approach to the debt box issue, citing the overreach of the agency as the reason for their discontent. The case, which is currently being unraveled with revelations of bogus claims, has not only caused a financial burden, but has also done emotional damage to the parties involved. Dion was left in a state of bewilderment after an appellate court found that the Securities and Exchange Commission's decision to deny a spot Bitcoin exchange traded fund was arbitrary. At the same time, the dishonest lawyers were found guilty. He accused the SEC of attempting to protect them from the consequences of their actions. The frustration is obvious among attorneys representing XRP, and claims are flying that the Securities and Exchange Commission is engaging in games within the courtroom. Even Paul Grewal, the chief legal officer of Coinbase, expressed his disapproval of the Securities and Exchange Commission for provoking difficulty and then attempting to extricate. David Schwartz, the chief technology officer of Ripple, has also criticized the Securities and Exchange Commission seeker playing dirty in the debt box case. What happens to the market value? Even though the Securities and Exchange Commission admitted that they had made a mistake, the ramifications were immediate and severe, with the market value of the related coin falling by 56. XRP drew out a multi-year triangle that was almost comparable to the one it had formed after reaching its top in 2013 and then beginning a negative trend. According to one market observer, XRP was able to maintain its range-bound status because of its structure until a dramatic upward resolution in 2017. Added 4 zeros to its price. XRP will be closed for the month on Wednesday. Track a moment. We are focusing on the symmetrical triangle and the MACD. The previous time we were inside of a symmetric triangle, the MACD indicator crossed above 0, which resulted in a rebound with a parabolic move as a result of Ripple XRP falling behind the present bull market. A new symmetrical triangle, nevertheless, the lesson is more than just the particulars of the situation. The need for SEC lawyers to remember that they are dealing with actual people and their livelihoods was underlined by John Dion. The issue is not simply one of rules. Rather, it is one of fairness and justice. This is not merely a legal battle. Rather, it is a demand that the Securities and Exchange Commission behave responsibly and fairly when dealing with cryptocurrency enterprises. Not only are people watching, they also demand justice and fairness that goes beyond legal action. Attorneys who support XRP, such as John Deaton, have voiced their disapproval of the United States Securities and Exchange Commission C and Gary Gensler. This comes after the SEC filed a motion to dismiss the controversial debt box lawsuit to avoid the possibility of sanctions and penalties for misleading the court to obtain a restraining order and asset freeze against the cryptocurrency company Debtbox. Attorneys for XRP, including the SEC Chair Gary Gensler, have voiced their opposition in response to the show, his order, and penalties for lying in federal court that Judge Robert Shelby issued. The Securities and Exchange Commission has decided to dismiss the controversial $50 million fraud action that was filed against Debtbox. Within the context of the Debtbox action, the Securities and Exchange Commission has admitted to making misleading representations. John Dion, an attorney who represents 75,000 holders of XRP, has criticized Gary Gensler, the chair of the Securities and Exchange Commission, for this scandal that occurred when Gensler was in charge of the SEC. In recent charges that have been made against firms, he stated that attorneys for the Securities and Exchange Commission have not shown a genuine allegiance to the law. The Securities and Exchange Commission was subjected to severe criticism from several federal courts, including Judge Torres, who referred to SEC as hypocrites in the Ripple action. Please do not forget to subscribe to this channel. and give your views always on any update I bring on. Let's get back to our discussion. D, the denial of a spot Bitcoin exchange traded fund by the Securities and Exchange Commission was deemed to be unreasonable and capricious by an appellate court in the Grayscale case. Despite those astounding fact findings that would cause any lawyer, lay, or leader to recoil in shame and disgrace, the attorneys representing your organization proceeded to act in a manner that was completely indifferent to the truth in the pursuit of justice. Now you're trying to protect your corrupt attorneys from having to face the very law that they pledged to obey. And you are running away while doing so. Odd added down. Where's the Securities and Exchange Commission? Prominent attorneys such as Jeremy Hogan and Bill Morgan have raised concerns regarding the sudden switches and tactics employed by the Securities and Exchange Commission. They have pointed out that the agency has been adamant about pursuing a significant fraud case, but has subsequently retreated when confronted with the possibility of adverse consequences. The strategy that the Securities and Exchange Commission commissioned Shikook and the complaint was attacked by other attorneys such as Jeremy Hogan and Bill Morgan. They stated that the SEC asserted that fraud for multiple millions of dollars was committed against Americans, but that it decided to drop the lawsuit to spare itself from shame and sanctions. In response to the Securities and Exchange Commission's unjustified lawsuits against cryptocurrency companies such as Ripple, Binance, and Coinbase, XRP attorneys have complained that the SEC is misleading judges by demanding jurisdiction across the cryptocurrency industry. The Coinbase Claw, or the embarrassment Paul Gree, also criticized the Securities and Exchange Commission's attorneys for withdrawing a lawsuit after causing damage to the companies and requesting that he be dismissed without prejudice. David Schwartz, the chief technology officer of Ripple, had pointed out that the Securities and Exchange Commission had acted improperly in the debt box action. He condemned the CSC for shamelessly distorting facts to obtain the or before the opposing party could defend itself.